last time
Oh, second semester.
we talked about what rights are included in this concept of fundamental rights and how do they apply against the states. I explained this theory that the court has adopted of selective incorporation through the due process clause of the 14th Amendment. And you saw at the end with my big bubble that pretty much all of the Bill of Rights has been selectively incorporated piece by piece, except for just a few couple minor things like jury trials in civil cases and indictments, grand jury indictments. So for the most part, you can sort of, from now on during the semester, assume that when we're talking about these individual rights, the same thing applies whether it's the state government or the federal government. A slight, detail about pleading, really, when you're, writing a complaint, is that if you're filing a suit against the federal government, you need to make reference to the Bill of Rights itself, right? I'm filing this action because of the violation of the First Amendment. When you're doing it against the state, you have to throw the 14th Amendment in there, right? The violation of the First Amendment rights as incorporated via the 14th Amendment against the states. Not a big deal. Probably not going to throw you out of court because of it, but proper pleading is always important. And you might get thrown out of court. A curiosity, in Puerto Rico, we had to plead it sort of in the alternative because the Supreme Court has never addressed the question of whether Puerto Rico is a federal creature or is a state under the 14th or 5th Amendment. And so you have to say, the due process clause of the 5th and or the 14th Amendment. It's kind of freaky like that. As you might have seen from D.C. v. Heller, D.C. is a federal creature, right? So you plead that as if it were the federal government. And so you might, want to watch out for weird places like that. If you're in an army base, it's a federal creature. If you're even though it might be located within a state, strange things like that. Now the second question that I want to talk about or the third, is another part of these, against whom do these things apply? And the question here is not whether it's state or federal government, but whether government or private parties, right? Can you bring claims for violation of your constitutional rights by other persons, private parties, be it corporate parties or natural persons? And this whole area of the law is what the court has called the state action doctrine. I'm calling this an overview because, as you might have noticed from the reading, it's a very complex area of law, right? There's a lot of sort of interlocking theories that the court has used in different cases. Some of them are not completely consistent with each other. It's one of those, right? Like judicial question, political question, and standing. And I'm not going to go that deeply into it. I'll just talk for a little bit today. But again, for the bar, if you have questions later on, throughout this year or throughout the next year, feel free to come to me and we can discuss it in more detail. The state action doctrine begins with this very famous case that we've mentioned before, the civil rights case. Right? And you're going to see that the slaughterhouse cases, the civil rights cases, I'm going to start talking about equal protection and slavery today. And you might begin to pick up some themes, right? And I'll go into that in more detail in a little bit. But all of these things are interrelated. Right? They all have to do with individual rights. In particular, they have to do with equal protection. And they all have to do with race and slavery, right, and the Civil War. And so when you're reading these cases, and you come back to them, sort of try to have in mind that bigger context, right? Is the court here strictly talking about state action, or is there something, else behind what the court is saying? So for a second now, I'm just going to talk about state action, but just keep that in mind. This case arises out of the creation by Congress of the original Civil Rights Act of the 1880s, which is part of Reconstruction, right? Which is the movement after the Civil War to guarantee the rights of the recently freed slaves and their descendants. So there's a lot of context and subtext here. And what the court does here is say, the Constitution, right, as I said the first day of class, constitutes government. Right? It's a document that is intended to create, delegate powers to government, limit those powers of the government. It is not a document that is intended to regulate private conduct. And therefore, all of the rights that are included in that document are only opposable against the government. They have nothing to do with private parties. Right? So the big, sort of bottom line statement of the state action doctrine is that the Constitution only applies to government. Now, I cannot stress this enough. I don't know how many times I've heard learned counsel and even learned judges talk about private party violations to constitutional rights. That is wrong. As a general rule, and as a matter of black letter law, we can discuss whether this is, correctly decided or not, but this is the law. So this idea that Google might violate your First Amendment rights, Google is violating my constitutional right of privacy. No such thing. Google is outside the scope of the Bill of Rights. This idea, when a kid tells his parents, "Oh, you can't tell me to shut up, I have freedom of speech rights." No. Your parent can. The government can. But your parent can tell you to shut up as much as he wants. Subject to, child abuse laws, but that's so the general rule is that the Constitution only applies to the government. And therefore, all of these beautiful individual rights that we're going to talk about over the semester, from a constitutional perspective, right, you can only sue the government for violating. Now, that does not necessarily mean that's a separate question from the question of whether statutorily either the federal Congress or the state legislatures can give you extra rights. And so that's what was happening to some extent in the civil rights cases, right? The civil rights cases isn't a direct lawsuit under the Constitution. It was a lawsuit under the Civil Rights Act that Congress had passed. Now, you know that Congress later on in 1964 passed another Civil Rights Act. And that one is good law, right? That one's the one we saw in Katzenbach and the Heart of Atlanta case and the Olive's Barbecue case, in which the court said, yes, this is valid exercise of the Commerce Clause. And remember I said, well, they did it under the Commerce Clause, they didn't do it under the 14th Amendment Equal Protection. That's weird. Well, this is why. Right? Because in 1883, the court had already said that under the 14th Amendment, that legislation is not, Congress could not enforce these rights against private parties. Under the Commerce Clause, 100 years later, they could. But in 1883, so again, this is Reconstruction, right? There's a whole process of trying to guarantee rights for the freed slaves. This is a huge strike against Reconstruction from the court. It's a huge statement saying this Civil Rights Act that you just approved, that guarantees the right to own property, the right to enter into contract, the right to, go to public accommodations, et cetera, is unconstitutional from a federal perspective. So go to your states, have good luck there. Now, what does this mean practically, right, for the black population in the U.S.? Well, if they were in Massachusetts, they were good, right, because Massachusetts was protecting them. But if they were in South Carolina, they were pretty much screwed. Questions about civil rights cases? Remember, by the way, that this is, as it respects the 14th Amendment, right? Again, equal protection, due process. Only applies, or I should say, does not apply for private parties. Not only doesn't it apply directly, but it does not give Congress power to enforce the rights against the private party. Now this is somewhat related to what we have already talked about and we'll talk about more in terms of Section 5 of the 14th Amendment, right? Remember, Section 5 says, Congress shall enforce through appropriate legislation the rights herein conferred, or whatever. The civil rights cases rules out the idea that Congress can, through Section 5, hold private parties accountable for equal protection violations. So again, it's a severe limitation of that power. Now, you can have an argument whether that's right or not, right? And there's a whole bunch of people that think this is wrong. The whole intent of Congress in this period, right, of this Reconstruction Congress was precisely to give power through this amendment to itself, as ratified by the states, to do precisely this, right, to control discrimination in all its forms and shapes. And so you see a very particular type of, nowadays it's called judicial activism. You see the court exercising its power in a particular way. Now we're going to see that in a minute, sort of in its ultimate expression in Dred Scott, which was a little before this. But I just want to point out this idea of the court sort of interfering with the will of the elected bodies from the perspective of limiting individual rights. And then we'll see the court sort of do the opposite later on, right? Interfere with the popular will to grant individual rights. What I was going to mention is that the 13th Amendment is a whole other story. As I mentioned the other day, the 13th Amendment does apply against private party because its language is fundamentally different. And it establishes a complete and absolute prohibition of slavery, right, and involuntary service. And so the court couldn't read that one in a limited fashion. Now, a lot of the cases that you have in your readings have to do not so much with this general rule, but rather with the exceptions to it. When is a private party doing something in such a way that state action sort of can be read into the situation? What does action versus inaction mean? Right? So some of the controversies here have to do with what is government action versus government inaction. And an interesting case is this first case you have about the father and the son, the chaining, in which the state has already acted, right? Deciding that this child should be with his father. Then something bad happens later on. There is some evidence of child abuse by the father. The state doesn't do anything. So the state initially places the child with the father, then gets some information that the father might be abusing the child, but chooses to not do anything about it. And then something terrible happens, and then there's a suit, right? They sue the state for not doing anything to prevent the abuse. And the majority says, well, this is inaction. The state didn't do anything. Therefore, there is no state action. The dissent says, no, but you're looking at this the wrong way, right? The state initially gave the child to the parent, and the state has this whole framework of family relations law and child protection law. And its failure to do something within that, scheme of or framework of law that it has already subjected these parties to is a kind of action. And so I'm not going to go too deep into this, but you can see how this issue of how you characterize something as action or inaction can be a very slippery thing and will be ultimately determinative as to whether you have a cause of action or not against the government. To simplify this a little bit, you can sort of split these exceptions into two. Well, the big one, of course, is the 13th Amendment. And that's a very, idiosyncratic one. That's just the 13th Amendment. But in more general terms, you can split this into two. The first being what the court has called the public function doctrine. Now this refers to situations in which the government tries to delegate to a private party a function that has been traditionally only conducted by the state. Now the prime example of this is elections. During the Jim Crow era and segregation and all those fun times, when the court and the legislature, when the federal court started enforcing the rights of African Americans to vote, what some of the southern states would do is they would pass a law delegating the conduct of the elections to a private entity, right? And then the private entity would stand there with the booths and everything, they're running the show, and they would, take the black people and not let them vote. So the black person goes and sues. It's no state action, right? You can't sue me because I'm a private party. Well, the court says, no, you can't do that, right? The conduct of elections is a traditional public function. You can't immunize yourself against equal protection by simply having a private party do your job for you. There's a couple of examples that haven't been litigated, but that I think are very interesting and very current. One of them is, you all familiar with our friends from Blackwater? Private contractor that is, or used to be, I think they still are, I'm not sure, running some of the war operations in Iraq. Right? The government hires this private contractor, sends them to Iraq to fight the war, or to do kinds of things that normally are done by the army. What happens if, you know, you're a U.S. engineer or something, and you happen to be, I don't know, you happen to be called Mohammed something, and the Blackwater people confuse you for an Iraqi, and they, you know, beat the crap out of you. And then you sue in U.S. court if you're a U.S. citizen for violation of your constitutional rights. The argument would be made, well, you can't sue us because we're not state actors. We're a private party. That would be a situation in which you might be able to argue, right? Well, you're running a war. That is a traditional public function. And you don't get to immunize yourself from liability. The other big example that's going on right now is with private prisons. Right? A lot of states are privatizing their prison system, having private corporations build and run prisons. And then you throw the prisoners in there and you do all kinds of nasty things to them. You put them in solitary for years, you forget to feed them, you don't give them proper medical treatment, whatnot. Normally, you would have a cause of action for cruel and unusual punishment or due process or whatever against the state. But now it's a private corporation. Is that, again, a traditional public function in which you can't immunize yourself that way? Not clear right now. I think there's a good argument to be made in both of those cases. So, litigation that might happen in the near future. The second one and you see this a lot in some of the cases that we read. Sometimes the court uses the word employment, which is a particular type of entanglement. In situations in which the state is, for lack of a better phrase, in cahoots with a private actor. Right? It's not that they delegated the function completely, but they are somehow involved in the process of whatever the private actor is doing that is bad for someone. So, anybody watching Elementary? The show? Just one person. You know, what do you guys watch?
Homeland.
Is that what's going on? Is the new generation back to reading?
HBO.
Game of Thrones?
Yeah, for sure.
Okay. Let me think of an example.
Archer's a favorite?
No,
Sherlock Holmes is a private consultant with the police, right? And Elementary in particular, he's always breaking into people's houses, doing all kinds of things that violate the Fourth Amendment, right? So you could argue, well, he's not a state actor, right? He's a private citizen. Well, yeah, but he's got a contract with the police, right? So You can make a couple of arguments there. You can make an agency argument. It's an agent of the state, just like an employee, right? You don't have to be a full employee. Just being a contractor makes you an agent. But you can also talk about him being sort of entangled with the government. It's not the best example, but it's kind of a fun one. So Sherlock and the NYPD in elementary. In here, you can throw things like judicial enforcement, right? And that's most of the cases that you read for today have to do with it. Now, Shelley v. Kramer is sort of the big one there. In Shelley v. Kramer, you have private citizens contracting with each other, right? Reaching this agreement under which you're not gonna allow African American people to live in these houses in this neighborhood. The state had nothing to do with it, right? Private citizens reaching private contracts regarding their privately owned property. So why is there state action? Well, the interesting thing is when you actually go to court to enforce that contract, the court says, you have sort of entangled the state in that process. Now you are forcing the state to engage in conduct that would otherwise violate the 14th Amendment. And by doing so, you reach this exception to the state action contract. And there's entanglement between the state and the private party. And in some cases, as you might have seen, you can sue both the state and the private party. And that's where it gets really confusing. That's where you have all these cases that are contradictory. In some cases, the court has said, yes, you can sue the private party. Some cases, they have said, no, you can't sue the private party. You can sue the state. And it gets confusing and sort of subjective. But the general idea is you're involving the state in what originally was a private action. Now you're using the state in some way. The power of the state, right? The coercive power of the state to enforce those private agreements. When we reach the case was mentioned this very briefly, but when we reach free speech, one of the huge cases in free speech law is New York Times v. Sullivan, which involves a defamation case. Again, private parties, New York Times and Mr. Sullivan. Why is it a free speech case? Well, because the court understands that when you use the power of the state through a defamation tort claim, you are implicating the state sufficiently to constitute state action. We'll talk about that more when we get to New York Times. Questions? That's all I'm going to say about state action. Do you guys have questions about the case? Yeah.
Does it really just come down to, is the action versus inaction, action is always actionable, and then plus these exceptions?
Right.
In addition?
Yes. Yes. And of course, in that action versus inaction characterization, there's disagreement of the court.
Right, where the line is.
Right. And you know, one of the big things, you have a big note that talks about statutes, right? Is a statute, the fact that the legislature approved a statute that gives a private party certain rights, is that enough? Right? And for the most part, the court has said no. The statute by itself is not enough, right? There has to be some kind of judicial enforcement procedure, which is kind of weird. But yeah, it's action plus these exceptions. Or, I mean, you can call them exceptions, you can call them a particular type of action. Nothing else? Shall I read grammar? All right. Well, that concludes sort of an introductory phase.